I am doing well, I think.
Good to see you, like always.
Good to see you too. I saw you yesterday.
2 days in a row. Fabulous. Who is this gentleman? Mr. White.
Page
So, new case.
33 and 34.
All right. Good morning, Mr. White.
Sir.
Sir, you stand charged with two offenses. You're charged with driving while intoxicated. Second offense, you're also charged with failure to stop and give information. On the DWI, you're facing up to.
Right away, the judge lays out the stakes: jail time, thousands in fines. Notice how fast the courtroom strips away any sense of normalcy. This isn't just a traffic ticket, tits, potentially life-altering. Quick question for you. If you were in Mr. White's shoes, would you try to fight it or cut a deal?
A year in jail and or a $4,000 fine. On your other case, you're facing up to 6 months in jail. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 1st, 2025, officers were dispatched to a major crash at the intersection of Westheimer and Synott Street. Officer made contact with the complainant. The complainant stated she was driving and she was at the intersection when the light was green. She proceeded through the intersection, saw the defendant's vehicle run a red light at a high rate of speed, and the defendant's vehicle was struck by the complainant. The damage to the complainant's vehicle was approximately $9,000. The complainant stated she was never contacted by the defendant to exchange information. The officer made contact with the defendant and observed glossy eyes, slurred speech, a moderate odor of an alcoholic beverage, and unsteady balance. The officer also observed swaying and disorientation. The defendant stated he was driving his motor vehicle when the other motor vehicle struck his, that he was the sole occupant of his vehicle, and that he was driving the damaged motor vehicle that the officers observed on scene. The defendant admitted to consuming alcoholic beverages prior to operating his motor vehicle, that he was coming from a steakhouse and was on his way to his friend's home to sleep, that he had drank 3 bottles of beer at a gas station across the street from the scene, and that the defendant stated he did not consume illegal drugs that night. He also stated he was unsure of which street he was on and rated his intoxication as a 5 from a scale of 1 to 10. The defendant stated he parked his motor vehicle, was going to walk to an apartment complex where the officer stopped him to tell his friends to call the police, and that he could have called the police given that the officers observed the defendant's phone on him. Center field sobriety tests were administered, HGN 6 out of 6, walk and turn 4 out of 8, 1 leg stand 3 out of 4. The defendant was read the DIC and refused. A blood search warrant was signed and executed.
Did you want to say something?
I did, Judge. I'm not sure about the court, but I'd like to hear a little bit more about leaving the scene. It sounds like
I didn't hear
I
anything.
didn't hear anything on
You didn't say anything about the FSGI.
So on the FSGI, the complainant stated she was never contacted to exchange information. After, and then also furthermore, I can read from the complainant.
He stayed there, right?
No, Your Honor. So allow me to read from the full.
And there it is, the big problem: leaving the crash scene. That's not just a bad look. It can upgrade your charges and sink your credibility. Prosecutors love this detail because it screams consciousness of guilt. But here's the twist. What if he really did just go to call his friend? Do you buy that explanation or not?
Gotta leave.
So he was found at a gas complex, apartment complex where he was stopped, and that's where he made contact with the officers. And the full DIMS, I can elucidate that.
So he wasn't
at the
scene of the accident.
No, Your Honor. He was later found at an apartment complex. That's where he was stopped, and he told the officers that he could have called police because they observed the phone on him.
Did you say how far?
Let me see the DMs if I can see.
And Judge, he's bonded on both cases. I mean, there's plenty of room for us to negotiate and work with the state on this. I mean, it may very well be.
I just want to make sure that, if he's charged with an offense, there's enough probable cause. And,
From DIMS is about 5 pages long.
Yeah, it doesn't look like it. They say the distance, just that they made contact with him at the apartment.
Where? At the apartment or?
There's an apartment complex where they stopped him. That was not the scene, and that's where they found him, and they saw him with his phone on him, and that's where they made contact and asked him if he could have called police. And he said he could have, and that he was walking to that apartment to get his friend to call the police.
And Judge, we have both locations of where the crash occurred and where he was found. If you could give me a moment, I can get the exact distance.
If that's the case,
I have a lot of problems
I
here.
have an identification question then, if that's the
I have-
both cases.
I have he goes to the gas station, he's drinking at the gas station, you know?
Yes, Judge, and because he did state he drank at the gas station across from the scene, and then
Do we know if he started drinking after the accident, before the accident? Did the officer ask?
well, he did state that he drank prior to the accident because he was at a steakhouse, is what he said.
Right.
Boom. That's the hammer. An ignition, interlock basic, a breathalyzer wired into your car. If he tries to drive after drinking, the car won't even start. Judges love this tool because it's both punishment and prevention. But let me ask you, do you think these conditions actually stop people from drinking and driving, or are they just a temporary band-aid?
You have no distance on as far as where he was from.
Locations, and we can find the distance. If you just give us a moment, we can see how far the two locations are.
Well, I am going to go forward with your, I'm going to find that there's enough probable cause to go forward on the driving while intoxicated. Have you run his license, see if he has a valid Texas driver license?
Yes, Judge, his license is eligible.
Okay, I'm now placing a restriction on your license, Mr. White. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I'm going to revoke your bond. I will put you in jail. I am ordering you also as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If we find that you're consuming alcohol or any illegal drugs, likewise, you will go to jail. No more PR bonds. Do you understand?
Yes, sir.
Now, you have a lawyer. Because you have a lawyer, I will waive your appearance so you don't have to waste your time coming to court, but you must stay in touch with Mr. DeLeaf and he'll tell you when you have to come back to court. If Peter tells me that he can't get a hold of you because you're playing games, then I will again issue a warrant for your arrest.
Your Honor, so it's 0.3 miles, and furthermore, upon reading the OR, there were bystanders on the scene that told the officers that they identified him as walking towards the apartment complex and failing to give information from the crash. So we have 0.3 miles, and a bystander saw him walking from the scene of the crash towards the apartment complex.
I will now, I'm going to find probable cause for now.
Okay,
Peter,
for now.
if you find something that's different later on, come
Okay,
back, we
approach.
can always talk.
Yes, sir.
You are also not allowed to drive unless you have liability insurance in your name on whatever car you're driving. We are sending notice now to DPS that you're required to have an interlock. So every officer in this state is going to know if you're caught driving a vehicle and it doesn't have an interlock, they're going to take you to jail. Do you understand? Okay, so I'll have you sign reset with Victoria. We'll have you get with Fleisher for your bond conditions, and after that, you're free to go.
Thank
Okay,
you.
guys,
Appreciate
take
it.
care. Miss Miranda, do you just want to reset?
Yes,
you go.
Your- I believe we're just,
Hold on a second. Do you mind hitting the soundbar button, please? Turn it on. Thank you so much. My soundbar's off. Bear with me a moment. Okay,
yes, Your Honor, I believe we're waiting on discovery. I reached out a couple of times to the state.
it's not. That's weird, huh? One more time.
Can you hear me?
Nope. Hey, she's here on Gaitan.
Okay.
Yeah. Gaitan.
Okay.
Is discovery complete?
One moment, I'm loading it. Okay. Let me see. Discovery is complete, Your Honor.
Do you have the blood?
This one, it was a breath case.
Oh. No, I can't hear. It's weird we can't hear you. Let me call IT.
Let me see. It's showing that it's picking up the sound.
You want to say something, please, or sing?
Hello?
There we go.
Can
Yay.
you hear me? Oh, okay. I was gonna say it was picking up my sound or showing that.
Maybe if you sing to us, you know?
Okay, so I do show that I have police reports in the body cam, but I guess,
What are
okay,
you missing?
I guess I'm not missing anything if he just said everything's here. Because I did reach out a couple times and I didn't get a response back, but I do realize the DAs have changed a couple times.
Yeah.
The last I heard, I was waiting on a possible dismissal. I don't know if anybody wants to update me on that.
Alex?
So it looks like a quick eval was done by Morgan, but we would request just like maybe a week to look at it one more time and then we can dismiss if we need to. But
You want to do that? Or do you want to do?
We can do that. We can set it for next week if that's fine, Judge.
Yeah, I'll waive it. What day do you want next week?
Let's see.
Top of 11.
Any day but the 16th.
We end up Fridays. We don't do Fridays because it's an enrollment thing. So
Okay, well then,
any day but Friday.
well, if he's asking for a week, I know the 15th will probably be too short.
I don't know. Can you think you can get it done by the
I think
15th?
there should be plenty of time, Your Honor.
Yeah.
Okay,
15th.
that's fine.
15th?
Yeah.
What are we expecting on that?
Eval for dismissal. Okay, cool. All right.
Thank you, Judge. See you next week.
Thanks. See you then. Oh, any more arraignments?
Earl White?
So for the interlock? Yes.
Okay.
Judge Council's also confirmed on page 5, top of page 5. It said he needs more time.
Good morning, Ms. B. How are you?
Mr. B,
Yes, sir. May I approach, Your Honor?
what's up with you?
Yes, sir, Your Honor. I am here on Mr. Alejandro Guardado.
Okay.
Just want to get a status of what are you expecting out of this case, Judge? Are you willing to keep him on probation or are you recommending residential? Or what is your take on it, Your Honor?
Have we done a TRAS?
Yes.
What is it?
I recommended, SAT research.
That's it. You know,
What was that?
they were a SAT.
What's that? Yes, easy.
Hmm? How long does it take to get in? How much? No, I'm not gonna, that's, I can't, that's just too much. So can we do it and then have them report when a bed opens? Yeah, I don't wanna hold someone 1 to 3 months without knowing if they're gonna get in. That's, you know, so do you mind checking to see and then let us know? So there's usually a wait to get in, but I think that that's unreasonable to have to wait 1 to 3 months. That's crazy,
Yeah, especially.
you know? Right. So let's see if we can do it to where we wait for one to open up and then he can do it then. Yeah, okay, sure. Petite. Hey,
Two things on the breath device and Mr. White. His vehicle's in the shop until February 12th. Can he
I'm a
do
portable.
portable until then?
Just advise him that he's gonna sign a no driving affidavit. Do not drive under any circumstance, anyone's car.
Um,
So we'll give him the portable device. Once he obtains the car, then we can switch it.
So he's in a rental car right now.
He needs an interlock on it then.
Can you put him in a rental car?
I don't know.
Can we put him on a blow schedule on a portable until then? If he's blowing 3 times a day, he's not drinking. Until he gets out of the, until it's February 12th, I told him he's got his truck back.
Guess I'll put him on a scram.
Let me talk to him about it and I'll reapproach. Can I, real quick,
And your other guy, check on, it's,
73 days old.
where is he
We
with it?
finally got all his appearances waived. We,
Yeah, but
oh, where are we?
Where is he?
We have finally done a full review of all the evidence. I talked to the prosecutor this morning about it. We are 1 letter short of a mitigation packet. I checked with my paralegal. We also, the state needs to review the case. That's what I talked to them about this morning. There's 4 or 5 things that I see as problematic. So they're reviewing, I'm finishing the packet. Should be done hopefully by the end of the week and I'll get it turned in. So if we could do one more reset, that'd be great.
It's not gonna be long, but I'll give you some time. Sure. And he's got to be here at the next setting and then we'll figure it out. So tell me, has anything changed with the PTI programs? Any news?
DWI?
Yeah,
So what we are saying, PTI packets to Bernadette Abbey, but in like a bigger scale. She's having a lot to look at, but the criteria, I think she's being a little more strict.
You have to actually submit the application now with the packet. So we submitted a packet 2 days ago. It was rejected because the actual application had to come with it.
but any hardline rules, like anything above a 16 is denied or anything above a
She's just
2?
in general, like she just denied one yesterday that was below 0.15, and that technically could have,
Really?
when she was telling us that. in the
True
case
first.
meeting. I just know it's below 0.15, that's all she told us about it, but, she's just being a little more strict on them.
That doesn't bode well for my 0.2.
Oh, I don't know specifics, Ron. We're still
What about,
on
is there still the line where if it's a 15, you need a mitigation packet?
I believe so.
Okay. All right, so we'll give you a couple weeks and then, he's got to be here, packet got to be done.
Talk to him real quick about scram versus no driving affidavit versus,
Yeah, you let me know what you want to do.
I'll be right back. Thank you, Judge.
Hi,
Judge Marty, question approach?
yes, ma'am.
Judge, I am back on Miss Smith, Shanika Smith.
Okay.
I wanted to provide an update with the court. I know we spoke earlier this week. We called in Interlock, which was the additional provider, and Will and I
Tell me
both
they said
called,
no.
and they still said no.
What?
Her make and model for her vehicle, we called the service department because they kind of transferred around to the person who was in charge of it. They were placed on hold. They came back on and said, unfortunately, her vehicle would not.
What
allow
is it? Is it
She has a Lexus 300.
the bubble looking car?
So I asked her for the make and model. She provided, and that's what I gave them. And Easy Locks was the first person she attempted. We then called Interlock, and they also could not install on her vehicle. And I don't know what it is about the vehicle, but they said no. So once we got that answer, we spoke with Ms. Gomez because we know with the portable device, there's going to be some issues. She's asked me, we just have 2 weeks so that they can figure out with the new administration and the new changes that are coming with the program, if there's something we can work around of some sort, or something they can suggest. So she said in 2 weeks, we'll have it all figured out.
Yeah,
and
okay,
what
not a
we're
problem,
judge.
for sure. Yes.
Thank you.
Joe. He's totally fine with the scram. He understands, and he says
Okay.
he has to work, so scram's fine.
So any alcohol, I'm taking his privilege to drive away. Let him know.
I told him that.
I don't care what it is. Let him know. Would you mind having him come up? Mr. White, come up.
Is he gonna need to pay for the scram, Judge?
Sorry? No, I never make anyone pay for it. I want you to understand that as soon as you get your car back, you must have the interlock on your own car. Do you know, I guess so, we need to figure out and have a date when you're gonna get your car back, because I can't imagine you're gonna be in a rental car forever because they're stupid expensive. Is that the day? Okay, so let's do what we're gonna do. So I'm putting a monitor on your ankle, so I know that you're not consuming alcohol. This thing is extremely finicky, so be very careful what you put in your body. And I don't care what your excuse is. If I find that you're consuming, you have any alcohol on board, I'm taking your privilege to drive away from you. Do you understand? That includes mouthwash, tequila, lollipops, hair dye. I've heard so many excuses. I don't care. Just you are old enough to know what to put in your body. If you don't, for example, like an energy drink, if you don't know, then don't use. That's the bottom line. Do you understand? Okay. All right. So we'll put it on. I'm going to waive the fee for you. I guess February 13th or one of those days after. Let's do the reset for that day so you can come back in and we can switch it. In
fact, I think that's the day we did the reset.
Oh, perfect. Okay. Whatever day. Yeah.
Judge, so for the IID, for time after that, whenever he does get the IID, do you want to have the scram removed then as well?
Yeah. Proof of the interlock installation first, and then we remove the screen.
Yes, Judge.
Yeah.
And then also for that, did you want the no driving or? We're still-
No, because he's driving a rental. That's why we're putting on the scram. I don't think you can put it on a rental. Okay,
Thank you, Judge.
please.
Did you change the reset date? February,
What day did you put?
March 13th,
Yeah, we need to do it for February,
February?
like
13th?
whatever day that they're gonna choose. Doesn't matter to me.
Thank you, Judge.
Thank you, Peter.
February 13th is a Thursday. Judge, is that a required appearance?
Yeah, so they can switch it out.
And Judge, if we do that, it's gonna take him probably, he's gonna set the appointment up. I guess he could preset that appointment up to do it. when he gets
Do you want me to waive it or do you want to waive it or what do you want to do?
No, I'm just worried you want to have the device on by the 13th, it may be the 20th.
Yeah, I don't, Peter, whatever day you want, doesn't matter to
Yeah,
me.
we can waive this appearance, that'd be great. And then
Okay.
I'll be able to give you any information update.
Yeah, but just, we need it done by that day. But soon thereafter,
We're gonna move it a week past that, just so we make sure we have the device on. it.
Okay. Sure.
And I guess if he's getting it scrambled, maybe he should come to court.
That's what I'm saying, because he's gonna have to come here anyways to get it removed, right?
I mean, what I can do for that, I'm making a note of it, work on it, and he can provide proof of the installation. We have the forms and stuff to pretrial services.
Okay.
So once he goes there and provides proof of getting the interlock in there, I'm permitting him in his conditions now for them to allow him to take the scram off.
But he has to have proof of the interlock first.
Yes, I have that in there.
Judge, you said that's a required appearance? William, Gerard, come up. Also, Judge Fleisher is on Zoom.
Yeah, I see him. I got him.
Oh,
Mr. Williams, you're charged with terroristic threat of a family or household member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 29th, 2024, the officer is dispatched to a disturbance involving a weapon at an apartment in Harris County, Texas. The officer made contact with the complainant, who stated she and the defendant are in a dating relationship, that she left the club with a witness, and she received a call from the defendant asking where she was at. The defendant was upset because she was not at the apartment when he was there, and the defendant was texting her that she better not be at the apartment, and that would be her best bet once he got to the apartment and she was not there. The defendant was texting her, but the complainant stated that when she returned to the apartment, she observed the defendant walking towards the motor vehicle she was in with a black metal object in her hand, banging on the window of the motor vehicle. And the defendant told the complainant to get out of the motor vehicle or he was going to drag her ass out. The complainant felt threatened and called the officer. The defendant sent text messages to the complainant reading, "It's cool because whenever I catch you, I promise you on my life, bitch, I'm going to show you. You think I'm bullshitting? Let that bum ass have you made for each other on my mama. So I'm telling you to stay where you at. But for real, whenever you come here, bitch, you better have backup because I'm going to drag you, bitch."
Mr. Williams, there is probable cause to go forward. I'm ordering you as a condition of your bond not to have any contact with this complaining witness and not to be in possession of weapons. Do you understand? There is a protective order that has been issued in this case. Get to know it, because if you violate the protective order, the state can file a violation of protective order against you, and it's one of the worst cases you can pick up. You understand? We're going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria, sign a reset. We'll have you take your seat in the jury box. So we'll get your bond conditions. We'll have you sign it. And then you'll be free to go.
I had came to court when I was, and they had appointed me in court.
That was for probable cause court, but it doesn't.
To be able to have a, well, he had found me edited to be able to have a court appointed lawyer.
I have a financial affidavit here that says that you make nearly $8,000 a month.
Well, I'm not at work. I'm not gonna be able to go to work until this case is over. So I've been out of work since October.
All right, so let's do this. I'll have you fill out a new one. Just put all the information on it. I'll file it, and then assuming you do, I'll give you a lawyer today. Okay? But I need you to fill out another one. I cannot give you a lawyer when I have an affidavit that says that you make that much. So I need to know the true number. No. Let's not talk about the case now.
No, it's not about a case. It's about me going to work. I have my.
Let's do this. Hold on. I don't want you to say anything where just let me have you look. Let me have you do this. If you qualify, I'll give you a lawyer. Talk to the lawyer. The lawyer can come talk to me. Okay? All right, please.
all right, Judge, the second arraignment is right now, it's on the side there. Go ahead and sign it.
Neela? Hugh,
Hey, Judge.
what's the word? Hi.
Gerald Williams.
Bond custody.
He's on bond, yes.
Okay.
And I was just appointed to him. After speaking with him, he was placed on, they put a GPS monitor on him, and also a curfew. And Judge would like to see if we can get take the GPS monitor off. He already has a no contact order with the complainant. And he works in refineries, so he does 12-hour shifts where he's either working all night or then all day, and then he's also trying to do DoorDash as well.
Is this, The problem is that he just pled to, if memory serves me right,
Yes,
he just pled to an interference. It's the same complaining witness,
yes, Judge.
right? And now he has a terroristic threat, same complaining witness where he makes threats. Does he have any prior assaults against this person? I see a prior impeding breath.
Yes, same complaining witness. That
Yeah.
was dismissed. I can look at the reason for why it was dismissed.
I'm near her, I don't.
Did we get the
she lives
curfew
with
taken
her.
off so he can work? That's the big thing. The GPS will stop, that's, but that's, just so he can make a living, Judge. I mean,
Come on. How do I know that he does that?
he's no longer with the complainant as well, so they're broken up and.
I don't want you to go anywhere near this complaining witness. I don't want you to go anywhere near where she works, where she lives, prays, nothing.
Sir, I don't want no more computers with this situation.
Wonderful. So,
I've already got all my belongings from over there. We no longer have communication with each other. I don't even want to deal with the situation because it's being too much for me. If we've been through this situation, you call the police on me, then.
okay, I don't want you to, you don't have to say, when you get cancer, you cut it out, otherwise it kills you. People can have that same effect on you, right? We're working on the third, same, so cut it out. And that's it.
I'm done.
So he's asking me to take the curfew off. What do you do for a living?
I work in a refinery, I'm independent contractor for total safety. I actually have a job that's going on right now that they just called me on, that I have to almost miss due to the fact that I'm facing the truth. I just signed up for DoorDash. I'm just trying to keep myself busy. That way I don't have to be into no trouble at all.
Okay, but I don't want any more issues. If I find one iota, I'm gonna go nuts.
I promise you, you won't have to worry about it.
Okay. All right, Hugh, I'm leaving it on for now, so that we know. And then please reach out to complaining witness, let her know what we've done, so that if she has any issues, let you guys know, you can bring it to our attention, then we go from there. Yeah?
Absolutely.
Okay,
The
all right,
curfew,
man.
we're removing the curfew though. Right?
Yep. Mr. Williams, just cut it up.
I promise you. I'm done.
All right, thanks, Judge.
Thank you, Judge.